joining us this evening for the Brooklyn Law School panel on representing the fashion client, co-sponsored by the Dennis J. Block Center for the Study of International Business Law, the International Law Society, and the Intellectual Property Law Association. We hope that you enjoy the panel this evening and will join us after for the reception upstairs. With that, I'll hand it over to your moderator this evening, a woman who needs no introduction, Professor Claire Kelly.
Hello. Thank you, everybody. Thank you for coming. Thank you. I am the moderator, which means I am just going to tell you who's up here and move things along, because this is a fantastic panel. And there's a group of people who have discussed many of these issues before. I think we're going to have a very lively discussion. We also are going to look forward to your questions. And I will tell you there are bios on the chairs, and they are extensive, and you can read those. We have Guillermo Jimenez from FIT. We have Barbara Colson from Stuart Weitzman, Stephen Gertzke from Olshan Grudman, Karen Seal Lapidus from Lomans, and Frances Hadfield from Grunfeld Desiderio. I want to say a special thank you to Frances because she brought this program to our attention here and has helped us organize it. I also want to say a special thank you to our team here at Brooklyn Law School, Liz Alper, Jay Brady, Bethany Blankley. They do, and so many other people here. They do so much to make our programs run so well so that we can just show up here and talk, and that's really appreciated. So I'm going to start by turning it over to Guillermo, who's going to give us some introduction to representing the fashion client.
All right. Well, welcome to Fashion Law, representing the fashion client. I'm going to start out by trying to give you an idea of the scope of fashion law, what we mean when we say fashion law. And I might not cover it all. So if I fail to, don't forget to buy a copy of our book. It's available on Amazon. You can have it in 2 days to your house. For a modest, I think $72 or something like that.
Or used.
Now, if you're a law student and you can't afford that, because then you can't buy top ramen for dinner, you might get, this is free, I believe. You can probably get it in your library. It's a copy of this fall's journal of the New York State Bar Association Committee on Intellectual Property, and they have a nice little section on fashion law. So the first 4 articles are a lot of the information in our book in kind of condensed form, especially for lawyers. So that's another place where you can find some of this information. So now let me get started. And I like to start, before going straight into the concepts and the details, I like to start with an example, because it gives us something concrete to think about. And fashion is all about beautiful objects, so let's look at some pictures. And the first thing I want to start with is this beautiful picture of our president and his first lady on a very memorable day that we all remember, and in a beautiful gown that got a lot of press for the first lady and the lucky designer who became known for having designed it. Now, the next picture is of a company here in New York called Faviana, and that's them at work the next morning. And what they are doing, you can see, they're putting together the little flowers that they're going to use for their exact copy of Michelle Obama's dress. And this is a ceremony that goes on all around the United States every time there's some famous person that walks down a red carpet. So the classic example is the Oscars. All right, when Joan Rivers is doing her harassing interviews, or those famous celebrities, the people at Faviana are at work, sketching from the television. And faster than Jason Wu can have his originals in stores, Faviana has their garments out. Not just Faviana, but there's a few other companies, Prom Girl, ABS, that do very well. Now, it's an interesting question. Why is this legal? Somebody created something, and immediately afterwards, before they can even begin to sell it, someone is selling something that's close to a duplicate. First thing I'll mention is this is legal in the United States. It's the essence of fashion law in the United States that it's legal. But it's not legal in Europe. So there is a legal issue here, and we have a law in front of Congress now that would render this kind of copying copyright infringement. So that's the first example I'm going to start with. And I will underline that those of you that are familiar with fashion, the more familiar with fashion you are, probably the less shocked you are by that. You know, people that know the fashion industry know that it lives off imitation and knocking off. My students often say, so what? But if you consider other areas of copyright, you know, if a movie or a book came out, a big, you know, this Jonathan Franzen book, if someone was able to transliterate it almost sentence for sentence and come out with their copy that evening, wouldn't we find that shocking? But for some reason, we don't find it shocking in the fashion context. Another example I want to give out, this is from yesterday's Daily News. I kind of was surprised, that it was relevant to our presentation today. Pierre Cardin, one of the legendary figures of modern fashion, was quoted in the Daily News, quoted by, I guess WWD was the reporter that broke the story, that he was ashamed of this year's Pierre Cardin designs. That's kind of interesting. How is it that one of the most famous designers in the world will, just after his show in Paris, will say, I'm ashamed of those designs? Well, I'll tell you why. Because he didn't produce those designs. Those are produced by his licensees. Pierre Cardin is one of the founders not only of modern fashion, but of modern fashion licensing. Reputedly made over $1 billion in sales from licensed products. Had over 800 licenses extending even reputedly to sardines. There was a Pierre Cardin line of sardines. Can you believe that? So question is, now what kind of a situation is this when we have, people representing brands worth hundreds of millions of dollars that claim to be ashamed of their products? We had a similar situation Barbara might want to talk about. She was involved, my colleague Barbara Colson, in a Calvin Klein case where about 10 years ago Calvin Klein came out and said he was ashamed of his jeans. He went on the Larry King show and he was ashamed of it, but it was the same situation. It was the designer was unhappy with the designer's licensee. And that's a situation that's kind of interesting. We may come up with and look at again. Now, I guess I skipped one. There was one that, for whatever reason, I was going to include and didn't make it into this particular PowerPoint. I'll just mention it briefly. My next slide was going to be a famous blue box that some of you may be familiar with that comes from Tiffany's. It's like when your boyfriend has done something really bad, you may get one of these blue boxes. And what I did was next to the famous blue box, I put a picture of the logo of eBay. Because your boyfriend better not buy it off eBay if he really wants to make you happy. Because Tiffany did some research and they found out that over 70% of the Tiffany products sold on eBay were fake. And only 5% could be verified as real. Despite this, those of you that have intellectual property as part of your practice, you probably know that there's a very high-profile lawsuit by Tiffany against eBay, which Tiffany has pretty much lost. And it has been held that eBay was not guilty of contributory infringement of Tiffany's trademark, even though these counterfeits or these fakes were available. And that's an issue that is very much perplexing the fashion bar right now. So those are just 3 examples I want to give you of the kind of concrete issues that we face and that we discuss in our book. Now, to turn to our definition of fashion law, sometimes when we talk to lawyers, lawyers are skeptical. Fashion law? Haven't heard of that. It wasn't on our curriculum in law school. And so usually what I try to do to break the ice a little bit with the lawyers is I say it's kind of like entertainment law, but for fashion. And that seems to communicate something. They get that. All right? But now that I have an audience that's willing to go into some depth, we think it's more than that. When people think of entertainment law, they primarily think of the IP issues, and we as well, when we talk about fashion law, we're talking primarily about IP issues, but we take a broader perspective. We think that fashion law is everything that the general counsel or GC of a medium to large size fashion company should know. And we had some meetings at FIT where we brought together general counsels and representatives of various fashion law clients or fashion clients, and we asked them, what do you do for your clients? what do you do as a GC? And we did some questionnaires and surveys, and we came up with a list of, disciplines that I've mentioned here, starting with intellectual property, going on to licensing, anti-counterfeiting, commercial sales, corporate law, employment law, commercial leasing. My colleague here, Steve Gursky, wrote our chapter on commercial leasing, advertising law, and customs and international trade law. It was Francis that wrote our chapter on customs. So all of these areas can be absolutely vital to the functioning of a fashion company, as we'll see throughout our discussion. To take, Francis area customs. Well, over the past 20 or 30 years, items that used to be manufactured in the United States gradually all moved over to China, or Morocco, or Caribbean Basin, or various other places where apparel is manufactured. And so now increasingly we need to know customs issues, because if our stuff gets stopped in customs, we're in a lot of trouble. Now, why is there a need today for fashion law? Probably the main concept I want to emphasize is that fashion has undergone a dramatic transformation over the past 30 or 40 years. Fashion, the leading fashion designers have become world celebrities, and they generate revenues now in the billions of dollars. Also, large fashion companies, LVMH, Federated, Liz Claiborne, Jones, have acquired more and more brands and have become large conglomerates. And not surprisingly, they need expert legal counsel. And law firms, the big law firms around the world, are trying to provide specialized counsel. It's not enough to be an IP lawyer now. You have to be an IP lawyer who understands fashion products and the fashion business. And one other thing that, I put here, I added this at the end, designer misunderstanding. One interesting thing that we find counseling fashion companies is that the fashion designers have trouble understanding intellectual property as it applies to fashion. And there are a lot of misconceptions out there in the business. In New York right now, you go to any big fashion company and you talk to their designers, and you'll see that they'll tell you, this item we're not concerned about because we changed it 3 times. And they will tell you that there's a rule in the law, in American law, that if you change a fashion item 3 times, you're safe. Other people will tell you, no, it's 7 times. Other people will tell you, no, it's 60%. Whatever that means. What does it mean to change a fashion design 7 times or 60%? Well, if you think about it a little, you'll see it really doesn't mean very much. There are false rules of thumb that permeate the industry and cause some problems, because designers think that they're safe. They've changed it 3 times, whatever that means to them. But according to a jury or a judge, no, it still looks substantially similar to what they copied from, and they're going to be guilty of copyright infringement. So we need to help educate designers a lot better. Now, I've mentioned that entertainment law is a useful analogy. The only reason I come back to it now is to say that we're trying to follow a little bit the trajectory of entertainment law. In that, first you have a course at UCLA Law School taught in 1964. Then you have bar association sections. Then you have other law schools that start to pick it up. Then you have books, treatises, etc. So we decided the right place to start for us was a general handbook for the industry that would be useful for designers, for general counsel, and for law students as well. Now, to give you just a feel for why, again, is fashion law important? Are there really people practicing it? Well, if you do a simple Lexis search to find out how often certain parties end up in court, you see that fashion people end up in court about as often, if not more often, than people in traditional or other entertainment industries. So we see that a clothing manufacturer, there's 775 mentions, shoe manufacturer, 731, and we look over at entertainment law categories like book publisher, music publisher, film producer, and the appearance and the number of cases generated is about the same. So there is a growing fashion jurisprudence. It hasn't been collected or studied as much as the entertainment law jurisprudence. Now, just in terms of money, the fashion industry is twice as big as all the entertainment industries combined. And that's kind of surprising to people, because in America, we're very proud of our entertainment industries. We have Lady Gaga and Justin Bieber, things like this that dominate the world. And we think they must make a lot of money, and they do make a lot of money. They make tons of money, but not as much as fashion, all right? Because we all have to wear clothes every day. And so you see the apparel industry, about $200 billion, just dwarfing the size of the other entertainment industries. Now, to come back to examples of kinds of disputes that might arise in a fashion context, I'm forever thankful to Forever 21 because they copy so much that they always give us examples. They're just terrible copycats at Forever 21, as you can verify by going to your closest Forever 21 and going shopping. A lot of my students do. And what they're very good at is copying popular garments, items from the current season. A couple of years ago, they copied a Diane von Furstenberg dress. The Diane von Furstenberg was on the left, and the Forever 21 was on the right. And if you look at them from 10 or 20 feet away, you start to get that blurring effect where they look pretty much the same. Now, Diane von Furstenberg was not happy about this, as designers are often not happy. They're offended. Not all of them. Sometimes they even take it as a compliment. But quite often, people are offended. And so here I want to make the first point, which is a dress like this is actually two designs. When we're talking about the design of the dress, we have the design of the fabric print, the surface design, and then we have the cut of the garment. Okay, so those are two different concepts. And in American law, we do not protect the cut of the garment. So when I say fashion design, that's what I mean. I mean the way that particular garment is assembled. Maybe could have been from drawings, but didn't have to be. All right? Now there's another design, the design of that fabric, because we could make this same dress from different fabric, right? The fabric is copyrightable under U.S. law. And if you make your fabric too similar to the Diane von Furstenberg fabric, which I'm afraid Forever 21 did, then you're liable for a copyright infringement suit, which can happen. And you're going to fall into this trap if you believe that if you change something 3 times or you change 6 times, then you're safe. Okay, now Forever 21, I suspect they're more sophisticated than that by now, because they've been sued so much that they know what's going on. And we'll come back to Forever 21 later, I believe. They're always a good example. Another example of the money at stake in these lawsuits is a case that, as I mentioned, my colleague Barbara worked on, is the Calvin Klein versus Linda Wagner case. It was Calvin Klein versus Warnaco. Linda Wagner was the very famous, legendary CEO of Warnaco at the time, and it was a $200 million lawsuit. I mean, it involved distribution of Calvin Klein jeans and Calvin Klein underwear. And so there's big money riding on fashion issues. One of the key issues here was, if you saw a pair of Calvin Klein jeans in a Costco, would you lose respect for Calvin Klein? Well, you can argue in court about that for a long time. Ideally, the contract would be helpful. In this case, the contract did not quite solve the problem. So these are the kinds of things that fashion lawyers and judges in the fashion bar have to become increasingly familiar with. Another case down towards the bottom, here I use a lot, is a case of Louis Vuitton. Louis Vuitton being pretty much the world's largest fashion company, has very deep pockets when it comes to enforcing their legal rights. They're very serious. Sometimes people think they're perhaps a bit too aggressive. But there was a much smaller company based in Houston called Haute Diggity Dog. And Haute Diggity Dog makes dog toys, chewable dog toys. Fortunately or unfortunately, they decide to name them with some cute names, amongst them being the Chewy Vuitton, because dogs are supposed to chew it. And then the shoe is the Jimmy Choo, and then the perfume is the Choo-Nell No. 5. And I don't know what Jimmy Choo and Chanel, as Choo-Nell, thought about it, but Louis Vuitton was not amused. And they came after these people. But fortunately, these folks in Houston were actually making money with these dog toys. Making enough money, they fought. They fought, and they were able to win a victory against Louis Vuitton, extending the concept of parody to trademark. We're familiar with parody from copyright, but not so much from trademark. Now, I'm running out of time here. Just a couple key points that I want to make to set up the rest of our discussion. The essential fact in American law that impacts fashion law, that impacts fashion, is that copyright strangely does not help us out. All right, so we need to understand why that is. All right, and that's because when the United States was founded, it was over time we decided that patent would protect useful articles, copyright would protect creative articles. We decided also later that clothing is a useful article. Therefore, it's not subject to protection from copyright, with the exception of surface prints. All right. Also, some items that are sold at fashion, like jewelry and accessories, do not fall into that similar classification, so they are protectable by copyright. So, fashion designs are not protected by copyright in the United States. Prints, accessories, jewelry are. Partially because of the weakness of copyright, we in fashion, you may have noticed, we emphasize heavy on trademarks, right? We have our Dolce & Gabbana sunglasses, so everybody can see that they're Dolce & Gabbana. All right? One of the reasons is trademark lasts forever, never runs out. Copyright and patent run out sooner or later. And not trademark. Also, it's very easily protectable, and if people go too far, you hit them with counterfeit action, which is a very serious kind of action. Fashion lawyers eventually learn that you can have overlapping or layers of intellectual property on a single item. You could have a utility patent, you'd have a trademark. Like Gore-Tex used to have a utility patent, also had a trademark. Use those in combination. The act that has been proposed that would change U.S. law, which would be a very, very dramatic change, would be to extend copyright-style protection to fashion designs, to imitate the European approach. And it's a big debate right now throughout the fashion industry and amongst law professors and attorneys as well. And the two basic sides, I think two of the best articles written on it. One, there's Professor Jeannie Suk with Professor Scott Hemphill at Columbia, published an article last year in Stanford Law Review, where they're in favor of the passage of a Design Piracy Act. A couple of years ago, Cal Raustiala and Chris Sprigman published an article called The Piracy Paradox, where they argue that too much intellectual property protection can stifle an industry, that economically our fashion industry is more vibrant because we allow copy. So that debate right now is ongoing. I wouldn't be surprised if on this panel, some of us, we take different sides of that debate, and we'd love to hear from you as well. So I'm just about out of my slides. I'm going to impose on my coordinator just one more slide here. I was talking about Forever 21 just a second ago, and a lot of people think, well, the U.S. law, the fact that we have an absence of protection, well, that can be good. If we did create protection for fashion designs, we would encourage frivolous litigation, right? Frivolous litigation might be good for some of us that are going to be litigators, right? But for the clients, for business, for America in general, it's not a good thing. But I say, wait a second, why are we so quick to assume that the European regime will lead to more frivolous litigation? Because look at these lawsuits. Zara, in that 5-year period, 2003 to 2008, was sued 0 times. H&M, twice. Forever 21, 53 times. Okay? Zara and H&M, they're the European companies. Forever 21 is based in America. All right, so where's the frivolous litigation? Where's all the litigation? It seems actually like maybe we have more here. Maybe the absence of protection stimulates more copycat, which stimulates the brand owners to try and fight back somehow. So I just leave you that kind of question as to which regime is better, and we'll be glad to return to any of these issues later. Thank you.
Thank you. That's terrific. I know I already have questions, but I think Barbara Colson might be answering some of them. So I'm going to let her speak first, and she's going to talk a little bit more in terms of introductory materials, but also about licensing and anti-counterfeiting.
Okay, I'm going to follow up on many of the things that Guillermo started with. and talk a little bit about my company's brand also, which is a shoe brand. I'm sure a lot of the women in this room know Stuart Weitzman shoes. We use, there are trademarks, there are copyrights, there are design patents, and we have been very successful in our business in seeking design patents for our shoes, which have been very useful in helping us enforce our intellectual property rights. Design patents are really bingo, what I would call bingo, if you've got a design patent, which, by the way, is relatively expensive and takes quite a bit of time to get. And you know as a business matter that the shoe that you're going to protect, since you're investing some money in this IP protection, is going to be in the collection for a few years. It's a great tool. So these are some of the shoes that we have design patents on. Many of them are in the collection. The benefit of having a company where our head designer is still an integral part of the company, unlike the stories that Guillermo referred to. Stuart still designs our shoes, and in fact still makes our shoes. He spends most of his time in our factories. So we've had very good success. This is in the U.S. enforcing our design patents. There's some more. We also have trade dress protection this is not the greatest shot, but if any of you have been to any of our stores, our Madison Avenue store, for example, in New York, you see we have a ribbon store design, and we have a trademark registration on the supplemental register for our ribbon store design. And actually, it would be an interesting exercise to go on the PTO database and look at the file history in this case, because a couple of my interns actually wrote the response to the office action. And these are 2 Ls who did it last summer, because it was initially rejected, and we figured out how to get it, and we have it. And actually, interestingly enough, in Europe, we were able to get protection for that store design in a second, because the protection in Europe is so much stronger. Trade dress is very difficult in terms of protecting designs, and this is a couple of recent examples. Steve Madden, who copies a lot. You can see the Balenciaga case and the Autumn Paper case. And again, these were brought under the concept of trade dress infringement. And they're tough, and these are both, as far as I know, still in the works. Related issues have to do with celebrity infringement of fashion trademarks. A recent case involving Beyonce, who sought to register the mark Sasha Fierce for perfume, and was opposed by Abercrombie, and ultimately renamed her fragrance Beyonce Heat, because of opposition by Abercrombie. Another case involving Paris Hilton and the patented heart-shaped pad in a shoe. EU is just such a dream, and I'm going to give you two recent examples in my office. France and the EU afford just much stronger protection, which of course makes perfect sense, because it's the bread and butter of what they do. This is just a slide on the kinds of information that it's good to obtain from your design people. Keeping records when something is designed, who's designed it, when was it created, any kind of source material. Somebody buys something at a flea market. Keeping good files on the history of a design of an item. And the EU has actually a two-step process. Two different registration. They have a concept of unregistered designs, which we have used successfully recently, and of course they have registered designs, which have a 5-year term. But even with an unregistered design, you have protection in the EU, which is really amazing. This is a recent case. I just got a check on this today, so I'm in a very good mood because it added to my miserable legal budget. The shoe on the left is our Gigi Ritz shoe, which is a very popular shoe. The shoe on the right was sold in a store in France called Andre, which is kind of like a Nine West type of a shoe store. One of our business people saw it. We wrote them a cease and desist letter, and guess what? They ceased and desist. That shoe, that G.G. Ritz shoe, would be unprotectable in the U.S. under our current IP protection. So this is a great story. And this is basically what we did. We gathered evidence. We purchased a shoe. You have to purchase a shoe with the court bailiff. Then we sent a cease and desist letter. We threatening to institute proceedings before the French court. We didn't have to get that far because we wrote a very strong letter. They were willing to settle. They actually destroyed the shoes. We got a little binder today with pictures of the destruction. I mean, can you imagine this in the U.S.? This just doesn't happen unless the goods are counterfeit. And we got a check, a big check, a really big check. So voila. Now on the other side, we are the victim in this litigation. The shoe at the bottom is our blingy shoe. It's a jelly. And the shoe at the top is a shoe made by an Italian manufacturer called Menghi. When we got a letter from Menghi threatening to sue us if we didn't discontinue sale of the blingy shoe, we tried to settle. Stuart, my boss, said that design is not original. It's a traditional, what's called a D'Orsay pump, based on, a design of the Duke of D'Orsay from 16-something or other. It's been around forever. But guess what? Mr. Menghi in Europe got a registration for that design and sent us a nasty letter. We've spent a fortune defending it because my boss was really stubborn, and sometimes as a business matter you need to just bite the bullet and settle these things. It's just not worth making a point because one of the things Menghi did was he brought a couple of criminal actions against us and showed up at our shoe show in Milan with prosecutors, in two different regions. Both of the public prosecutions were ultimately dismissed, but money. In the meantime, we show in our response, we moved. What we did, rather than stop making the shoe, is that we moved before the OHIM, which is the administrative body in Europe that handles these registrations, to invalidate Mr. Menghi's registration, and we showed these other examples of other companies making this style of shoe. That case is pending before the OHIM. As I described to you, we had the prosecutions, which fortunately were dismissed, but again at great cost to us. And as we speak, we're trying to settle this. And my boss is meeting with Menghi, and apparently Menghi wants to manufacture shoes for us. But so we'll, to be continued. That's the scoop. The next thing I want to talk about briefly is, sure, go ahead.
I just want to ask a question about this. It comes up in more general discussions about copyright, about abuse of copyright. Sure. So do you think Stuart Weitzman can afford to defend that? And they do. Do you think that the European system has any downside, or are smaller companies that might be making legitimate knockoffs, let's call them, or knockoffs that would be in the public domain, are they scared away by it? Is there an abuse potential here?
Absolutely. I mean, we're a small company, honestly. We can't afford this case. Okay. I mean, this is eating up a third of my budget this year, and I'm not happy. So I would have settled this case if I had more control over it. For exactly what, it's just not worth it. And I understand Stuart is, it becomes I'm creative and I don't copy other people, and this is a typical, this shoe is nothing original. But yes, I mean, you raise a legitimate question, which is going to be something that I'm sure that has come into the discussions about the Schumer bill, which we've talked about, the amendment to the copyright law. And it's, as a practical matter, I could argue on either side of this table as to whether that change in the law will add anything to the jurisprudence. I mean, who is really going to be able to afford it? I mean, I've been a general counsel to three very small, less than $300 million fashion companies in the last 10 years, and you're dealing with legal budgets of anywhere from $250,000 to $500,000. So can you really afford to make a point? Isn't it easier just to live with the knockoff, or like this case, just say, okay, we'll stop making the shoe. We don't really care about it. We only made 3,000 pairs. And don't forget that this Mengi case, this is only in Europe. We can sell 1 million copies of that shoe in the U.S. We just can't sell it in Europe if we settle it. So it's a very good point, and all of these things are expensive. I mean, we've spent $100,000 on this case already, and for what? I don't know. Now, how do we make money? That's the next subject, which is licensing. Licensing is, how do you build a brand? I mean, the short answer is licensing. And I want Steve to weigh in on this. Let me just run through a few slides, because he has done all the major licensing work for Tommy Hilfiger from the beginning of time, and really turned that brand into a mega brand through licensing. It increases profit and revenue stream. You've got a designer like a Vera Wang or a Kenneth Cole or a Kate Spade, and you want to make. Kate Spade's a handbag manufacturer and wants to sell sunglasses with her name on them. Her expertise is in handbags. So you enter into a license agreement with a Safilo, who's a eyeglass manufacturer, and Safilo pays the designer a royalty, and the more of these licenses you have, the richer the brand becomes. And I think Vera Wang is a great example of that. A wedding designer who's basically turned that wedding industry into a multi-million-dollar enterprise with sheets and towels and mattresses and perfume and tabletop and anything you can think of that's vaguely related to weddings, she's licensing. So it increases the brand exposure, expands the company's operations into alternate manufacturing, because our company, we manufacture shoes. That's what we do. We have a licensee for handbags. We also have licensees for retail stores. When we want to open a store in London, we enter into a retail license and distribution agreement with somebody who knows that market, who will open up a Stuart Weitzman store, and under a license agreement with us, which has all the bells and whistles in terms of protecting our brand. So this is a huge part of IP. Of brands and building brands. It's very important. I won't go into all these slides, but it's very important in terms of negotiating these licenses to really understand the partner, to know that you're marrying this person, you're spending your life with this person, and if you don't get along, it's going to be a disaster. And I've seen, and Steve has seen, many examples. And I think the Warnaco Calvin Klein license is a perfect example of just companies not speaking to each other. And the key issue in these these luxury brand licenses is that your licensee really understands where you want to distribute product. And that was the big issue with the Calvin Klein Warnaco issue, because imagine how Bloomingdale's felt when they saw Calvin Klein jeans in Costco. That's the worst thing that you can do to a customer, to a retail full price customer, and that's got to do with not discussing where the licensed goods are going to be distributed, because don't forget, the licensee is in charge of the distribution. It's very important to have the infrastructure. A lot of small companies are crazy to jump on the licensing bandwagon, but don't necessarily have somebody internally who's going to manage all of this. There's so many issues. This is a whole course in negotiating and signing a license agreement. Lawyers, unfortunately, are often the last ones to be involved. And we often don't hear about things until the term sheet is handed to us and we're told to whip into shape an agreement. And there are so many issues: definition of products, whether this is an exclusive or a non-exclusive license, what trademarks are being licensed, the length of time. If you're the designer and you probably want a short license agreement so that if the licensee doesn't work out, you can walk away. And even with a short license agreement, your business people are going to be sick of the licensee in a year and want to know how they can get out of it. The royalty range, quality control is huge. Making sure that again, this has got to do with infrastructure, making sure that there's somebody who's really working with the licensee to make sure that the product is a true extension of the brand. And there's so many examples of, crappy licensed product, which doesn't look like the couture. And think of Ralph Lauren who is a master at managing licenses, where the product, the licensed product looks like the brand. Sales requirements, warranties and reps. If you're the licensee, you want to make sure that the licensor owns the trademark. When I worked for Calvin Klein Jeans, we had a licensee in Chile, and guess what? We didn't own the trademark in Chile. There was a pirate there who got there before we did and opened Calvin Klein stores in Chile. And it's a first to file country, and it took 5-6 years and lots of money to get the trademark back. So that's key. We are having a problem right now in China. Somebody filed a well-known pirate in China filed a registration for Stuart Weitzman in Class 3, which is perfume. We're never going to make perfume. Stuart's not a perfume kind of a guy. But the point is, do we want somebody else owning that trademark for perfume? Steve, can you talk a little bit about Hilfiger and your experiences in the licensing arena?
Sure. The most important thing, I actually, I went to Brooklyn Law School, graduated in 1979, and in the late 1980s, I started representing Tommy Hilfiger, and it was really the beginning of my education in fashion law. And what I learned about the licensing field was that for these designer companies, licensing has to have a long-term view. When Hilfiger got hot in the early 1990s, anyone and everyone wanted a license. We even had a license proposed to us for air fresheners for cars, the things that hang from your thing, the pine scented. And they could have made money on it. If your idea is just to turn money out of licenses, there's money out there. But what I learned from the folks at Hilfiger was that you have to pick your licensees carefully. You have to not chase after the money too quickly because you want to have the best licensees. So when you're a $50 million business, you want to do handbags, you're going to get a so-so handbag licensee. If you are a $500 million business, you're going to get the best handbag. You're going to have your pick of people knocking your door down. And so valuing the brand and building a brand through licensing, and Ralph Lauren is the king of this, picking the best licensees and not necessarily having the best relationships, but having the most control over the product. If you have what we have referred to as rent-a-brands, where they'll put their name on anything, you don't really value those brands. As a lawyer, as a consumer, you know that you're going to have a handbag that looks like one thing, and the shoes are going to look different, and the belts are going to look different, and the blouse is going to look different. But if you nurture licensing, then you end up building a brand because there's a consistency. I happened to represent Tory Burch, and I was able to see on the floor there's a Tory Burch bag back there. Tory Burch is building like Hilfiger did, not with 1 million licenses, building in a way where they're solidifying their presence in the fashion world in what they do best first, in clothing and in handbags and in shoes. They had one of the biggest selling shoes in women's footwear, and then they'll go into other things. Eyewear is next, and other home furnishings, and the world is open to them. But there's a lot that lawyers can do to participate in that, which is making sure that you have control over how things are made, how they're designed, and where they're sold. Because that's all the public knows. The dollars and cents of it makes the business people happy, but any contract lawyer can put together a license that says the royalty is 7%, 3% advertising, and have minimum sales provisions and all of that. That's easy. The fashion lawyer understands that the money is a big part of it, but it's the quality of the product that makes a brand last forever.
Good points. We had a license at Kate Spade for perfume, and there was the parties never agreed on distribution. And the licensee at the time was growing like crazy in the big box. You know, they were selling in Kohl's and Walmart, and they wanted to sell Kate Spade, and Kate only wanted to sell in Neiman Marcus and Bergdorf and place the high end. She didn't even want to sell in Macy's Herald Square, and that became a real issue because you can't make money if you're a licensee. You want to make money, so that is a very good point. I want to talk a little bit about counterfeiting, and Steve is also going to jump in on this. I'm not going to go do counterfeiting 101. I just want to call your attention to some of the more recent cases and some of the trends. Steve and I had been doing this for a long time. We worked together, doing Hilfiger anti-counterfeiting and representing other clients. And there was a period of time in the old days where everybody was bringing civil seizure actions, and then everybody was broke, and we worked together kind of getting people to do more group actions and also criminal actions, and Steve hired a prosecutor from Brooklyn, actually, to really spearhead the criminal action, working with law enforcement, prosecutors, and police to get more criminal actions. And now there's a kind of mixture of both. I think there's a bit of a return to civil actions, especially when there's a deep pocket, and Steve has spearheaded this and is getting some a huge judgment against Walmart on behalf of Tommy Hilfiger several years ago. There's a recent case, Fendi sued Filene's Basement, and this case just settled for $2.5 million. Fendi also got a huge $4.7 million judgment against Burlington Coat Factory, and that's an interesting case for you all to read because it's a very good example of how in-house lack of communication and not knowing the history of these cases can lead to an enormous judgment like that. Steve, did you want to say something about that?
No, I was laughing because I'm sure Karen has something else to say about it.
I'm interested, although I've never had any cases with Karen's wonderful company. That's
because we're very careful.
I know you are. She is the queen of this. I mean, we've talked about this issue. United States versus Lamb. It's very unusual for the federal government to bring criminal actions because they're so busy with terrorism. And this is an incredible case with pending big prison terms, $2.5 million in fines, and this was it's another case really worth reading because of the longevity and the details of the investigation. Coach, interesting. Coach is kind of the poster child these days, in my opinion, of kind of doing interesting things in anti-counterfeiting, and they recently sued the city of Chicago for failing to crack down on street vendors selling counterfeit goods. They say they've put them on notice, and they haven't done anything, and the city hasn't done anything, and the city who gives licenses to these people to sell product on the street. So it'll be interesting to watch this case. Coach also sued Target recently. Another interesting series of cases in New York involved the Mayor's Office of Special Enforcement, which Steve and I have both been involved with since the beginning, which is basically civil nuisance abatement actions filed by the city. The Mayor's Office has pulled together a team of various agencies, including Department of Buildings, the police department, the fire department, and they've basically looked at these buildings on Broadway, which I'm sure many of you are familiar with, in the 20s, where people are selling counterfeits, and for violations. And there are lots and lots of violations in those buildings, as well as in a lot of the shops in Chinatown. And they're putting together these actions involving multiple trademark owners and these civil nuisance abatement action. And obviously, what's the bottom line is that the city has the authority to seize the building if there are tax violations, building code violations, et cetera, et cetera. And this has been a very, very effective tool in not stopping counterfeiting, as we all know, but in making some headway. Burberry recently sued and settled with, I don't know the details because I didn't have a chance to call them, with TJ Maxx which is sort of heartbreaking. And there was a recent very big counterfeit goods federal bust in San Francisco. Again, a wonderful example of federal law enforcement. State law enforcement is very involved in these cases because I guess they have more time and more resources because don't forget, counterfeiting is both a federal and a state crime. And most trademark owners have had better luck with state. Steve, would you talk now about real estate and retail leasing, and why don't you trade places?
I never had to do this before. Just 2 quick points to add to something Guillermo said at the beginning. I think 2 reasons, and I've been around for a lot of the boom in fashion law, thankfully. 2 things that I think contributed to the change. One, in the world of counterfeiting, in the late 1980s, early 1990s, logos became more prevalent. The number of brands, there was always, Louis Vuitton's been around forever, but there weren't that many brands where the logo was part of the product. And that made it easier to counterfeit things. If you could just stick a label or a Tommy Hilfiger flag or a Tory Burch logo on something and then sell it, it made it easier, and counterfeiting became more prevalent. The other issue, and why the fashion issue and the fashion bill, the Schumer bill, has been changed fashion law, is that the technology over the past 15 years has increased so rapidly that it used to be that somebody went and saw Mrs. Obama wearing a dress and tried to sketch it and came close to it. Now they take a picture, they load that picture into a computer, and the computer spits out the same designs that were used to make the original. So the speed with which they can do it can knock out all the work that designers did. And I know there's people who are going to talk more about that law, but those are 2 things in my mind, having watched this for a very long time, that really changed the face of fashion law. I act as general counsel to a number of fashion companies, so I know a little bit about everybody's part, but my lot today is to discuss retail law as it relates to the fashion community. As Barbara mentioned to me before, it's kind of the stepchild of fashion law, because when people talk about fashion law, they kind of want the sexier stuff talk about the handbag I bought, or what I bought on the street, or should I buy it on the street, or shouldn't I buy it on the street. Retail law is more basic. It's very meat and potatoes. People have been doing leases forever. What makes a fashion lease different than another lease? Fashion leases, like many retail leases, have percentage rent provisions. You may not realize that it's not so much on a location on Madison Avenue in Manhattan, because those are traditional New York leases for the most part. But if you go to a shopping center in Short Hills, New Jersey, or an outlet center in Woodbury Commons, a likely part of the lease is also paying percentage rent. The landlord is your partner in the business. So landlords will want you to have a certain mix of product. They'll want you to either, at an outlet center, discount product a certain amount, or not discount it a certain amount. So that's an issue in retail leasing for designers. That's a business issue. When it comes to the issues that really relate to fashion and design, Barbara mentioned before the ability to get trade dress protection on a store design. One of the things that a designer has to be certain of when they select a location, first, like any other real estate, you have to select the right location. But very importantly for the designers who have a retail appearance, or a trade dress, if you will, is that they have to have the ability to change the store to look the way all their other stores look, so that they can in fact have a trade dress. If it were Madison Avenue, and I've just done 2 deals on Madison Avenue, and I did the Diesel lease on Fifth Avenue, and the Esprit lease at Rockefeller Center, and others like that. Rockefeller Center for Esprit was a very difficult store, because Esprit has a very bold appearance in the storefront of most of the stores. Rockefeller Center doesn't let you touch the facade of the store at all. Madison Avenue has a lot of streets that are landmarked. That's a big consideration, because Stuart Weitzman can have a protected trade dress and not be able to express it at a particular retail location, or have it look different than is typical trade dress, and they do have a store on Madison Avenue, because they can't change the facade to look like it. Years ago, Banana Republic was one of the most innovative storefronts. It was probably before most of you were paying attention. But when the first Banana Republic stores opened, they actually had what looked like a Jeep sticking out of the storefront. It got tremendous attention. They'd stopped doing it a number of years ago. But you couldn't do that every place. You certainly couldn't do that in a landmark place. So you need to be aware of the laws, and you need to have a meeting of the minds with the landlord to be certain that you're going to be able to do in the store that which you want to do. A business consideration that's unique to the fashion designers to some extent is what we call adjacencies. Who are the other people renting in the space? And as a lawyer doing the lease, do you want a commitment from the landlord if you're going into a new shopping center or even an existing shopping center to make sure, A, that Macy's is in fact in the center? Very often the anchor tenants are the draw for to bring the people to the center, and then people go to the designer stores. For many designers, they're not the destination. But people will shop, and then they'll stop in a Stuart Weitzman store or a Tory Burch store. So in many leases, we make sure that there are going to be these anchor tenants included in the center. But we also may want to be certain that Gucci is present or Tiffany's is present. Some of the names that have already been mentioned, to make sure that they've already signed leases before my client is committed to being in that center, to make sure that it's a place that you're going to want to shop, as opposed to my client being a luxury brand that stands out by itself in a place where there are much lesser products being sold. So these are issues that are somewhat unique to the fashion industry. The design of the store being a very critical one. We had that issue very directly with the Diesel store on Fifth Avenue. Diesel, the landlord of the Diesel store happens to be Gucci. Gucci owns the building, and the Gucci store was in the bottom of that building. One of the longest parts of the negotiation that we had was that Diesel has a very novel design. Diesel is owned by a company whose name is Only the Brave, and this kind of a picture of what you would expect to be Only the Brave would be kind of like a Native American, and there's a big picture or an engraving on the side of the Gucci building that is of a Native American. I'm not sure what the connection is to Diesel and why they picked that, but the point is that was very important to the owners of Diesel, that they be able to do that. On the other hand, Gucci's consideration was, this is our corporate headquarters in the United States. We're not sure we want people walking past that every day to come in for important business meetings. And so there was a long negotiation, but it was critical to the deal for Diesel that they be able to do that. So that was an important element of it, as it was immediately next door in the Tommy Hilfiger lease, that Tommy be able to have a more classic look on the building where, and I don't know if any of you are familiar with it, but there was a Fortunoff's on 54th and 5th Avenue. It was a store that was all black granite. It was the most nondescript storefront you can have. It was just black granite with big letters that said Fortunoff's. That didn't fit with the Tommy Hilfiger preppy image, and we negotiated into the deal. And in fact, in that case, Tommy spent so much money upgrading the store that it actually increased the value of the landlord's real estate. So they weren't resistant to it. They were actually thrilled by it, and required us to also renovate the entrance to their part of the building, so that you can do that as long as you make mine as nice as yours. So those are examples of issues unique to fashion designers because of the importance of the appearance of their retail presence. There are other nuances that relate to retail leases, but it's another reason why the issue of fashion law is there. In fairness, especially to my fellow Brooklyn law people, like any other specialty in law, it's the last 10%. 90% of what's done in fashion law is what everybody else does, what every other company does. An in-house attorney has to do corporate law and real estate law. And Frances does customs work, and I've worked with Frances and her firm for years. That's not unique to fashion people because there are people importing widgets. But there's things about fashion law that make her job for the fashion companies different. There are some things about real estate law, but 90% of a lease is a lease. okay? And 90%, the same things that I do, Guillermo mentioned that this is like entertainment law. It is. In fact, I represent Paula Dean from the Food Network. And a lot of the things I do to protect her trademark, register her trademarks, protect her trademarks, and license her trademarks are the same. One of the interesting experiences for me is that the difference is where I have clients on one end who will only allow their things to be sold at better department stores in the licensing arena that Barbara was talking about. Paula Deen is sold in Walmart. A zillion things with Paula Deen's name on them are sold in Walmart. That's great. That's where her customer is. And so you'll also, soon you'll see Serta mattresses with the Paula Deen name on it, something I just worked on, and you'll see eyewear coming out with the Paula Deen name on it, which I just worked on. So it's not, my point is, a lot of these skills, for those of you who are students, a lot of these skills are not unique to fashion. If you have an interest in fashion, it's great, but to the young lady who came to me with her mom and said, should I go into fashion law, is this for me? You can learn these skills. They will translate to other industries. Lots of industries have trademarks. Lots of industries have knockoffs. I represent a company who's in the house goods business. They own Mikasa tableware and Toll silverware, and many of the same issues apply. The licensing issues, the counterfeiting issues, the copyright infringement issues, the customs issues, they're all involved. So in terms of those, again, those of you who are students, every expertise is really the gloss, the last 10% of gloss, and that's what it is here. And I think, to Guillermo's point, having the book gives you that extra edge, the extra 10% that lets you step into an industry with comfort instead of having to learn your way in, which frankly is the way I did it, but it worked okay.
Thank you. I had a quick question before we turn to Karen. So with the trade dress concern, is there ever concern about whether your inability to completely replicate your trade dress in a new location might harm your trade dress and therefore could be a deal breaker?
There aren't that many companies. I have a client now. It's actually Tory Burch, and they called me about getting trade dress for orange carpet because they always have orange carpet and nobody else. It's a really bright orange. That wouldn't be an issue for a retail lease, but the answer is yes. When you're trying to, as Barbara knows, when you're trying to establish trade dress protection, that is protection that you get because you always do it that way. Every time you see the product, you identify it with the product like you would a trademark because it's always there. It could hurt, but if you have 50 stores and one isn't like that, it's fine. And that's what you have to do when you're a spree or you're opening. There are certain locations that designers can't resist going to, and whether there's landmark protection or not, or a very difficult landlord, they're going to do it and risk it, and risk that. And even when you have trade dress protection for a garment or a shoe, it's not usually every piece. It's certainly got to be more than a predominant percentage.
Great, thank you. So you're getting the sense that apparently all the Brooklyn Law School graduates, we were just placed on this side, 93, 74,
That was my
84.
request. I don't want to have anything to do with that.
So our next speaker is another Brooklyn Law School grad, Karen Lapidus from Lomans. Go ahead.
Well, I hope most people know Lomans, but if you don't, we are a national specialty off-price retailer of men's, women's, and children's designer apparel. So we sell designer apparel off-price to you all. So I thought I would discuss today how I deal with some of the issues that have come up in our discussions. In particular, some IP issues that I handle every day. So Lomans was established in 1921. We've been around for a long time, and we have some very, very long-standing relationships with, I would say, almost all of the well-known designers and manufacturers of apparel. It's important to us that the brands are preserved, maintained, because that's our business, and the intellectual property rights of our vendors, these designers, are important to us as well. So we want you all to know that when you come into Lomans and buy anything, that it is genuine merchandise, and it is, whether it's Tory Burch or it's Yves Saint Laurent, you know that it is what it purports to be, itself to be, that it is an Yves Saint Laurent sweater or a Tory Burch pair of shoes. So how do we ensure that? Well, we ensure it because I would say the majority, overwhelming percentage of our purchases from vendors are direct from the designer. So when you're purchasing directly from the designer, you really don't have an issue that something is not going to be genuine. However, Lohmann's is an opportunistic purchaser in that we will look at any available merchandise in the marketplace. So on occasion, that merchandise is available from a third party, a party that's either not the designer, the manufacturer, the authorized licensee. So what do we do in order to ensure that you're always getting genuine merchandise and that we never have an issue about intellectual property infringement? We have a due diligence procedure, and that's a good part of what I do at Lohmann's. So if we ever decide to make a purchase from anyone who is not the designer or an authorized licensee, the buyers know that they have to come directly to me to discuss what it is we're going to buy. So I'll sit down with them, and we have a due diligence process that we have formalized, where they have to do a number of things. As experts in their area, they have to go out to the designer's store, showroom, wherever they go, and ensure that whatever it is they're looking to buy looks and feels like genuine Chanel merchandise, Yves Saint Laurent merchandise. After they do that, they have to go to the vendor, this third party, whoever it may be, and get for me all of the documents that trace the chain of title to that purchase, the purchase of that merchandise, back up to the designer, to the manufacturer, to the authorized licensee. So they have to bring to me all of the purchase documents. So, for example, if we're purchasing a Missoni handbag, I want to see all of the documentation going all the way up to the Missoni sales document with Missoni's, name on it, and I want to make sure that all of those documents look genuine, that they don't have any restrictions on resale. I want to be comfortable that everything looks kosher. And if anything doesn't, I'll ask questions, or we won't go through with the purchase. Now, if I find that there's a problem with the paperwork, or something looks like it's not, maybe not what it should be, or there's some intermediate party involved in the transaction whose name I don't like because I know they've been involved in some disputes in the past, then either we will not go ahead with the transaction, or I will make a call to the designer. For example, Missoni, this happened a couple of weeks ago. We were purchasing some handbags from a third-party vendor, and I wasn't, comfortable with all of the paperwork, and we have a direct relationship with Missoni. So I picked up the phone, and I had the person that we have, our agent in Italy, call Missoni, get Missoni on the phone, and I spoke to them, and I got confirmation that these goods were genuine. I could purchase them, and based on that, of course, I wouldn't have a second thought purchasing the merchandise. I would also get a representation letter from the vendor. So I would make the vendor sit down, think about this, this actual, group of handbags I was purchasing, and represent to me that they know of no, reason they can't sell them to me. I can't resell them in the United States. And it's a due diligence process that I go through each and every time if we ever purchase anything other than directly from the designer or an authorized licensee. So that answers Barbara's issue about why you never see us in the papers, because we're very, very careful about the issue. And, we also, we have direct relationships with all of the designers, and we're careful. We're careful about ensuring that they know that, the merchandise of theirs that is sold in Lohmann's will always be genuine. So that's one issue that I deal with on a daily basis. Another issue I deal with, unfortunately, are cease and desist letters. I get cease and desist letters from time to time. which I find pretty annoying. And they usually involve something that I would have absolutely no knowledge of or control of whatsoever. So, I'm selling, I don't want to use anybody's name, I'm selling a shirt in the store, and I get a cease and desist letter telling me that the pattern on that shirt is owned by their client. They have a copyright to that pattern, and I better cease and desist in selling that shirt. It's nothing that I would ever know. There's no way I could ever know that the polka dot pattern on one of the shirts that I'm selling in the store violates somebody's copyright. But what do? So when I get one of these cease and desist letters, I will pull the merchandise immediately. I don't ask any questions. I don't, think about whether they're right, they're wrong, whether anybody has any defenses. I just pull the merchandise. And, I'm in the sort of enviable position in that I have a vendor, and the vendor who sold the merchandise to me has represented and warranted that the merchandise, there's not a problem with the merchandise, it's not infringing, they indemnify me, they pick up the defense costs, so I will pull the merchandise immediately, call the vendor, and let the vendor handle it. And 99.9% of the time, the vendor does handle it. So almost every issue that I ever have to deal with in the IP area with regard to infringement is always handled for me by the vendor, which is a very good place to be in. I do not ever have legal costs relating to IP infringement litigation. And, we talked a little bit about the fact that some of this litigation, or I think a lot of it, is a little bit, is trademark owners, copyright owners can tend to be sometimes a little bit too aggressive in that when they feel that they have a point to make, they will sue everybody in the chain of title, even though they know that, for example, a Lohmann's would have absolutely no way of knowing that their, polka dot pattern is infringing, but they sue us because, number one, we're a deep pocket, and number two, if we get upset, then our vendor is upset because our vendor doesn't want us to be upset. We purchase from them, and as a result, they're more likely to settle immediately, pay whatever the copyright owner asks. And, often these copyright claims are not, they really don't have valid claims, but because a Lohmann's doesn't want to be in court defending what is really not a valid copyright claim, often our vendor, whether it's the designer, whoever it is, will simply settle the claim because they don't want to drag us through a lawsuit. And, that's the way we're a very litigious country, and trademark and copyright owners often are litigious, particularly those like Louis Vuitton. And, if they have the ability to sue you, they will do that, and they'll do it regularly. And often they feel that this is a profit center. And many people feel that in a time of economic downturn, copyright and trademark owners use the threat of a lawsuit as simply another way of making money. And that goes on, and it's simply, a cost of doing business. And at least from my perspective, I settle as soon as possible, get out of the lawsuit, and move on.
How often would you say, out of the cease and desist letters that you get, how often do you wind up putting the polka dot shirt back on the floor?
Never.
Really? So it settles in a way but that suggests that the claim was valid, though.
No, not at all.
Oh, you're just saying
I simply
I don't want the shirt now.
I don't want the shirt. The vendor has to take it back.
Okay.
They have to refund.
And if the vendor is able to refute the claim of infringement, that's fine. They can go sell it somewhere else.
And they can refute it, and they can negotiate, and they can defend the claim. And as long as I don't have an expense, as long as I don't have an exposure, and as long as I'm not bothered by it.
Okay.
And,
I guess your
and
vendors
that's my
get that message, huh?
position. Yes, they
okay.
do.
All right.
And they're always very responsive. I'm their business. They don't want to upset me, and I don't. I have enough other things to be worried about. And at the end of the day, it's not my call whether it's infringing or not.
But you have cover anyway.
I always have cover because we don't purchase from vendors unless they can stand behind their reps, warranties, and indemnities, and they always do. That's another way you protect yourself.
Do you mind if I jump in for a second?
Sure.
So one of the things that Karen is mentioning that makes us overly litigious and the criticism, which there's always two sides of a litigation and an argument, is something that I take some pride in and responsibility for. And that is that when I entered this, I had been practicing, as I mentioned, I got out of here in '79. I didn't get involved in this area for about 9 or 10 years in the area of trademark protection. During that time, I was a business lawyer, and I understood business. So I entered the world of trademark protection late 80s, early 1990s, and I would start enforcing my clients' trademarks, and the attorney on the other side said, okay, we'll stop. Okay, thanks, that's a good start. Now I want you to give me all the money that you made on doing that. Now I'm not necessarily talking about Lomans.
Of course, that's the next question.
I'm not talking about Lomans necessarily. I'm talking about the person who sold it to Lomans or the person who made it to sell it to that middle person. There's a bad guy in this, a bad guy who made money. And the position I found myself in as a business lawyer, not a traditional IP lawyer who was satisfied with the answer that it's okay, just say you're sorry, pull the stuff, and we'll all go back where we started, was the question of why did it just cost my client $50,000 to get this stopped? I'm in a hole $50,000. Somebody made money. This doesn't work for me from a business point of view. And so I began making people pay, and when blogs were first starting, I was the victim of being blogged about, because I wasn't always by name, but it was Hilfiger's lawyer or Polo's lawyer. They called me Nike's lawyer. Whatever they called me, it was about the fact that I was making them pay for their transgressions. There are bad people in the process. It may not be Lomans. I'm not suggesting that it is. But there are bad people who copied something, put somebody's name on it without authorization, and making them pay makes them never forget my client and never forget me. And if you want to stop recidivism in this, make people write a check. It's a very cathartic experience. And so my colleagues and I have recovered, my group have recovered $50 million in these cases. Unfortunately, not on a contingent basis. So I only got paid by the hour to do it. But we recovered $50 million from the likes of Walmart and Costco and Value City department stores, the folks who were indiscriminate in their purchasing of goods and had relationships with no designers. A very different scenario than Lomans, but there is another part of retail. The people like Lomans and TJ Maxx, they generally do their homework because their business is to have relationships of constant supply. When you walk into their place, you'll always see the same designer merchandise. When you go into a Costco store, in the front of the store, you're going to see the designer of the day, whatever they could find on the open market. And they did it for years. Walmart did the same thing. They did it without discriminating against what was real and what wasn't. They really didn't give a damn. And they said so in court. And so we settled the case against them for $6.4 million. Our claim was much greater than that.
I remember deposing, when I represented Polo, deposing Costco before I came to work with you, Steve. And literally, in the depositions, the business people, some of who now are at the top of the heap there, testifying that they bought the Polo goods off the back of a truck. I mean, it's a joke, but it's true, and I think these companies have learned, partly because of the kinds of lawsuits that you brought. I mean, you got an amazing. What was your biggest judgment against Walmart?
We don't usually, to the point of the economics of these cases, a lot of our biggest recoveries weren't judgments. The $6.4 million was a settlement because they recognized, as did we, that going further didn't make sense. There were economics to this. So the numbers got big, the pain got big, the embarrassment. They didn't want to get the public embarrassment. I didn't run to the press, but the press pick up when they see public companies involved in lawsuits. They pick it up and they report on it right away, and it was embarrassing to them, as it would be to Lohmann's, and that's why Karen has a job, is to make sure that people know they buy the real thing when they show up at Lohmann's, and they do, and to know when they go other places. It's actually in Karen's best interest that I go after these other folks, because it keeps them from being unworthy competitors.
And
that's
that was going to be my question.
True, yes.
You
I mean,
want
we're
them to go
concerned
after
with
them,
the
right?
brand as well. I mean, the brand is what sells, and if the brand is not, you don't preserve the brand and the quality of the goods, then we don't have anything to sell.
If Costco's selling it, why am I going to Lohmann's? That's right.
Exactly.
And
right.
but your business is selling branded merchandise at better prices,
Absolutely,
right?
yes.
Your business isn't getting people into the store as it is for Walmart and Costco to buy the thing, because while they're there, they'll buy the chickens in the back of the store, or they'll
No.
buy 1,000 rolls of toilet paper. That's
No,
so they don't
no.
care as much about preserving designers. They just want to sell toilet paper.
Karen, did you have more?
No, I think.
Thank you, Karen. We're now going to shift to our last speaker, Frances Hatfield, and after that, I hope we're going to have had some discussion up here on the dais, and hopefully we'll have some discussion with you and some time for questions after Frances.
Well, I should start off by premising my discussion and saying, and now for something completely different. You've heard about intellectual property, and you've been hearing about counterfeiting. How many in the room know what the tariff schedule of the United States is? Hey, all right, I'm doing pretty good tonight. Okay, so regardless of your political leanings and your views on foreign trade, the fact of the matter is goods are not manufactured in the United States anymore. They are manufactured abroad, principally in countries like China, and they're brought into the United States. In order to bring goods in the United States, they have to be classified. It's a technical term, and it means that a duty rate and a number are assigned to them when they are brought into the U.S. And that's a tax rate. So everything brought into the United States, whether a tax is applied or not, has a specific code. It's just designed and updated by the United States International Trade Commission. You can find it online. It's 99 chapters long, and it classifies everything in the world, from pigs to jet engines to apparel. Everything has a number, and everything has a tax. And while the International Trade Commission publishes the tariff and assigns these numbers, the agency that is in charge with enforcing them is the United States Bureau of Customs and Border Protection, and I'll just refer to them as CBP. It's also the only agency that can provide you with legally binding advice regarding your apparel goods. So fashion articles are unfortunately subject to very high tariff rates. And I'd like to kind of give you an example here so you can have something concrete to hold on to while I'm talking about this. And I'll take a somewhat absurd example. Let's say I bought a lace hair net to wear in my hair. If I looked at the tariff schedule today, it's dutiable at 9.4%. And what that means to the importer is that if I purchased that good and brought it into the United States for $10, I'd have to pay $10.94. $10 for the value of the good, 94 cents for the tax. And that seems like a relatively small number when we talk about just $10, but I want you to take that to its logical extreme. If I bought $10,000 worth of merchandise, I'm going to pay nearly $1,000 in tax just to bring it into the U.S. So once you start thinking about the tax rate for goods to come into the United States, you have to add on a level of cost for every manufactured item. And so a lot of what I do is called tariff engineering. I'm looking to have my clients' goods be brought into the United States for the lowest tariff possible. So I'll go through the 99 chapters and say, what is my product and can it go elsewhere? Can I move it out of a category where it's going to be applied with a 28% tax, and can I move it over to a 6% tax? So let me talk about a case that I'm working on right now. We represent a little apparel company that you might know as Victoria's Secret, and they make a product that is a tank top. And in that tank top, they have a brassiere built into it. what Customs is doing is they're saying that that tank top with the brassiere built into it is dutiable at 16.6%. So let's say Victoria's Secret does $5 million worth of business annually on a single product. That's one style. I'm not talking about any other style. One style. $5 million, 16.6% tariff rate. That's a really, really, really large amount of taxes to be paying on that good. And so what we're working on right now, and the only place you can litigate cases involving duties is at the Court of International Trade, that's in Lower Manhattan, is we're challenging Customs and we're saying by having that brassiere built into the garment, it's actually a supporting garment. It serves two functions. It's a bra and it's a tank top. And because it falls under two places in the tariff, it falls under the tank top provision and it also falls under the brassiere provision. Applying the rules, we're going for last occurring and we want a 6% duty rate. So that's a little bit of what I do. I tariff engineer things to get a lower tax. So that kind of explains part of the process and what Customs attorneys do. So going back to some of the basic importing requirements and what's particular to the fashion industry, it's really important to remember that importing is a privilege and not a right. You don't have a right to bring goods in the United States. And Customs has a lot of information that they require from importers as a consequence of 9/11. And where importers typically get into trouble is that they fail to provide Customs with the information they seek. And I just want to give you a quick laundry list of how much information you need to give Customs in order to get a very simple product, whether it's a T-shirt, whether it's a hairnet, whatever it happens to be, into the United States. You have to provide them with the seller information. You have to provide them with that tariff code that I just talked about. You have to provide them with the buyer information, the consignee's information, the ship-to-party information, the manufacturer or the supplier of the goods, the country of origin of the goods, the importer's record number, any consolidators, the container stuffing location. It's a lot of data. You have to collect a lot of data. Just about a good that you had sewn up, maybe cost you $5 over in China, have sewn up, and you've got to provide all that information to Customs just to bring it in. So the fashion industry becomes complex when you start talking about, hey, I've got this really great design. I'm going to have it made in China very quickly and bring it to the United States and make a whole lot of money by selling it for 3 times what it costs me to make it. It's not so easy. There's a lot of in-between steps, and where young companies and small importers get into trouble is that they don't take care of all those important in-between steps, and they run into trouble with Customs, and suddenly they have a lot of harsh consequences, and I'll talk about that in a second. Customs attorneys don't actually file the paperwork with the U.S. Customs Service. There's something called a customs broker, and if you guys think that passing the bar is tough, I want to give you the passage rate for the customs broker exam. It has an 85% failure rate. So if you thought the bar was hard, there's not a whole lot of people out there who manage to become customs brokers.
Francis is a custom broker, I should tell you.
I'll tell you that, and I'll say that most attorneys can pass this exam after you've taken the bar because it's very good practice. And most of the people who take the customs broker exam, they are not attorneys, and they are dealing with complex laws, and they have a hard time interpreting them. So that might be part of the fail rate, but it's a high fail rate. So when I began, I talked about the cost of bringing goods to the United States and that 94 cents with the lace hairnet. 95% of the customs practice is very routine and it's very administrative. Once you start taking a look at a company's products and determining, you do what's like a product review, you do a line review of what their product is and what the classification is and what the duty rate is, so that you can go to the company and you can say, okay, you're making 12 products, this is what the duty rate on all of these products is going to be, so that you know ahead of time what your cost is. And new companies get into trouble because they don't do that ahead of time. And I'm going to give you a very terrifying example of what happened to a company that tried to make goods under a free trade agreement and failed. And this was a Florida company. They decided that they were going to take advantage of a free trade agreement. And as many of you know, free trade agreements allow you to have goods manufactured in a participatory country for either free or reduced rates according to the arrangements that we have with that company. And what this company did is that they had a pair of shorts manufactured according to all of the requirements of the free trade agreement, except for the lining on the back pocket. And the lining on the back pocket wasn't made of the right fabric. And it took a product that was duty-free and made it dutiable at 28%. And so you've just added a cost to your good. It's a law of unintended consequences. You've just added a completely unintended consequence to your design. And this design choice was made by a designer. The designer says, hey, I can put cotton in there and we can save 3 cents and get hit with a 28% duty increase. And so a lot of the advice that you can give your clients is, have you gone through and done a line review? Have you made sure that you have done everything you need to do according to the tariff? And if you haven't, you need to go to customs ahead of time. Take your product, take what those goods are made of, whether it's cotton, poly, whatever, take it to something called a national import specialist and say to the national import specialist, what's the tariff classification of my good? They'll tell you. They'll tell you what it's dutiable as. You've got an informal advice from customs saying this is the cost of the product, and you're not going to find out. And by the way, for that company that got that increase, they got to go back 5 years. It wasn't for one shipment. Customs went back 5 years to increase and get the taxes back and the interest back on the duties for all of those shipments. So,
do they get penalties?
In this case, they didn't. But and that's another part of what we do. So let's talk a little bit about the penalty process. Without getting into overly detailed information, Customs sends out something called a Form 28. And what that Form 28 is it's something that requests information from importers. It's very routine. So you as a small importer get a request from Customs to tell you what your good is. Tell them what your good is. They just want a little bit more, more information. With the volume of goods coming in the United States, I think Guillermo said $196 billion as far as the apparel industry. I can tell you that about 90 billion of that is for apparel. That was the import statistic from 2008. They can't track everything. They just can't. It's impossible. So what they do is they do a statistical analysis to see if they see anything that's not regular. And it happens a great deal in food cases where someone will say they're importing shrimp. I'll make it ridiculous. They're importing shrimp from Saudi Arabia. Saudi Arabia does not have a shrimp industry. So if suddenly you see that tariff number coming in from Saudi Arabia, that's the key to Customs. Hey, I want to ask a question of that importer because the country of origin of that shrimp, it's not Saudi Arabia. Okay, there's some kind of problem. So we have a very good idea statistically on a very large scale basis what our products are and where they're coming from. Apparel's coming from China. Shrimp is not coming from Saudi Arabia. So Customs will send out a questionnaire saying, okay, what do you got? Provide me with all the information that I just detailed you, the manufacturer, the buyer, the supplier. Give me all of this data. And then you have to provide it. Your broker's required to keep all that information for 5 years. And when you represent an apparel company, it behooves your client to know the factories that they're dealing with. In the same way that Lohman's is very careful about its vendors and is very careful about following up and making sure that the product that they're getting is real, every importer should do this. And you should tell your clients this, and you should make them know who they're buying from, know where it's being manufactured, know every little detail of it, and keep good records. Because Customs may come and ask questions, and the consequences, if you fail to maintain those records, if you don't keep them for 5 years, there's a record-keeping penalty. If you have the wrong product and you misclassify, there's a negligence penalty. If you deliberately said something is dutiable at 6% when really it was 28%, there's an 8 times penalty. The cost just increases exponentially from carelessness. And so a very easy thing to tell your clients when you deal with a new importer and they happen to walk in the door about something completely unrelated, and oh, by the way, I got this notice from Customs. Do you know anything about this? respond right away. Whatever customs wants, don't wake the guard dog. Give it to them quickly, efficiently, and say, keep a log. You've got one CF-28. Let's say you did nothing. You as your client did nothing wrong. Everything's clean. Their documents are clean. You did your due diligence. Keep a log. Put that CF-28 to the side. Write down when you got it. Keep a copy of the response that you gave customs. Always do it in writing. And then see if you get a trend. Is there a question out there that maybe you're not aware of, your client's not aware of, there's something going on? Because if they get 2 or 3 questions from customs about the same product, you've got a problem. It's the green light, or the red light, I should say, that, hey, you're about to get audited. And then customs is going to come in and take a look at all of your books and want to find out what exactly is going on with that product. So getting a letter from customs doesn't have to be a scary thing if you respond quickly and efficiently with the information that they need, but it can turn into a really scary thing if you're doing something wrong, if you haven't done due diligence ahead of time, by making sure your apparel good is classified correctly, by contacting customs to make sure that duty rate is correct, by making sure that you are complying with the free to trade agreement that you're bringing your goods in under. There's a lot of very nitty details, and it's something that you should just be aware. For those of you who have new clients or small clients, there are red lights, and you should be looking for them, and you should be paying attention. You don't want customs to have a great interest in you. And I'd like to give you a few very specific examples of omissions that fashion people sometimes they run into. You've heard everyone talk about royalties. Royalties are dutiable. Okay, so you have an NFL licensed product, and you're paying someone for the right to use their name. Well, whatever you're paying them, and that good's coming into the country, you're saying 10 cents a shirt. That's dutiable. That gets added to the dutiable value. Apparel people get into that trouble all the time. Assists. You're making a couture garment, and you've got to get that garment into the United States as quickly as possible, and there's some problem with your labels. And when I worked for a company down in Alabama right around the time of NAFTA, I hate to put numbers out there, but at that time they were transferring their production over to Mexico to take advantage of the free trade agreement. And we got into a bind because we needed that good very quickly, and so we sent labels across the border. We made up the labels in the United States, sent them across the border, and then brought that good back into the United States. Well, guess what? That got added to the dutiable value. We were providing something free of charge, et cetera, et cetera. These are the things that get companies into trouble all the time when they don't account for those items and additions as the cost of goods and the cost of manufacturing. Another mistake that importers of apparel, and I don't know why it's apparel, I'm going to have to pick on apparel importers for this because they do it frequently, and it's a little bit unnerving. They open up a shop, they'll start importing like crazy, and frequently they're trademark infringing goods. And they're not egregious violators. They're not someone who definitely ripped off Coach. They're not someone who definitely ripped off Tommy Hilfiger, but they're close. And so they get a cease and desist letter, and customs seizes their goods and destroys their goods. And they're like, oh, I'm in trouble with customs. And they close down their business, and they start a new business, and they're like, oh, now I'm a new importer. Yesterday I was, Spiffy Designs, and today I'm Star Designs. And they think that customs isn't tracking this. And if they can just, shut down their one business and open up a new one, it'll all be good and clean, and there'll be a clear record. Customs is a little bit smarter than that. They're paying attention. And if you become a habitual offender, by violating the customs laws, you can move into the criminal context. And people don't typically think of importing fashion as something that could end up with you going to jail for, but it does happen. And an instance where we had an importer that went to jail was where a president looked the other way. He knew that one of his employees was bringing in infringing goods. and had been doing it for years and had kind of a little ring going, and he never paid attention to it. Kind of said, I've got my regular importing business, and that's not part of my importing business, and one of my employees is doing something on the side, and I'm really, don't look over here. This isn't what I'm doing. He might be in my transportation department. He might be facilitating this, but, is it really that big of a deal anyhow? Yeah, it's a big deal. He ended up doing 30 days in jail for essentially assisting in the smuggling of infringing goods in the United States. So there can be some hard consequences if you have a client who's engaging or willfully not paying attention to these types of things. There are penalties for failing to redeliver infringing goods. Sometimes Tommy Hilfiger isn't fast off the mark. And some of the materials that are in your CLE materials is from the California Fashion Association, and I've included some pictures in there. And while this design bill is going on, there's a number of thoughts about whether the design bill is a good thing or a bad thing. But what happens with these pictures, you'll see a Diane von Furstenberg dress, and you'll see a 60s wrap dress that looks exactly like it, and you'll see a Claire McCardle circa 1942 pattern that looks very similar. And you have customs personnel who are not exactly, 50% of them have to be male, and they're not exactly into women's purses. They're not so quick to recognize that they might have an infringing design until the company calls them and says, hey, so-and-so is bringing in infringing goods, and then they'll try to get them redelivered. And you have an obligation to redeliver those goods. If you fail to redeliver them to customs, you can get a penalty for that. And that's one of the ways in which customs can help people protect their designs. You can, let me segue into that. If you represent a company that's developing a design, customs will protect your design for you. You can go on the customs website and you can record your registered trademark with customs to let them know, hey, I have this registered design, and if it's starting to become a hot commodity, you want customs to not let other people be bringing in your a Burberry similar pattern if you're, Burberry starting up. And you can also provide customs for those of you who are looking for a way to make money. You can provide a manual to customs that you could put together for your client. And customs has a section on its website where it gives you essentially a how-to. This is how to put together a manual for customs, include this information so that we will then be able to more effectively protect your up-and-coming design. So, a little business generation there. And so I've given you kind of the parade of horrors of answer your CF-28s. If you fail to answer your CF-28s, you might get a notice of action from customs, rate advancing your goods. I've told you that there are penalties. You can go to jail. There are all sorts of consequences to this. And I think what's important to remember is that there are some very beneficial things that you can do for the companies that you represent, and means that you can help them make money besides tariff engineering. And the one that I want to mention real quickly is first sale. One of the interesting customs laws is that let's say that you have an agent in Asia who, and we'll take our example of our lace hairnet, that they are going to contract out to a factory to manufacture that lace hairnet. And they're, let's say, before we had a dutiable value of 94 cents. So if the middleman in Asia contracts out to the factory to make the hairnet for $5, and the middleman's going to add $5 on when he sells it to the United States. In our original scenario, there was 94 cents of tax. Under the first sale method, the tax decreases from the $10 rate to the $5 rate, just by virtue of having a middleman in there. And that first sale then changes the taxable duty rate from 94 cents to 47 cents. So a means by which you can assist your clients in saving money is to help them set up a perfectly legal importing scenario where you put the non-dutiable aspects of the fashion company, whether that's advertising, there might be other administrative charges that you want to put in the middleman, and then keep the cost of just the pure manufacture of the goods, the sewing, etc. Keep that with the factory and be able to document, and we've talked about the importance of documentation, these two separate transactions. You can reduce the taxes that they pay by a considerable amount. How am I doing on time? Okay, all right. Let me see if I have anything else advice-wise. Oh, I want to mention Fish and Wildlife. It's a weird thing for fashion, and I just don't think I could get through this without talking about Fish and Wildlife. Designers are great people, but they come up with some strange ideas. Let's say you want to put wood toggles on your shirt. It matters where the wood comes from. If it's part of an endangered species, you can't import it into the United States. Leopard skin, they decide that they want to have like a little fur flourish. Well, what animal is that? And is it regulated? I mean, there's all sorts of weird things that the apparel industry is just, they're known for because you just have one designer. Wouldn't it be great if we did X? Well, all of a sudden you need CITES permits, you have Fish and Wildlife, things that you have to look into. It's just a weird area of fashion. And if you have an apparel client who looks to be putting animal or plant of any nature on their goods, whether it's on your purse with wood buttons or whatever, find out what genus and species that is. It may actually have a problem with it. So one little more weird aspect of the apparel world that people just typically don't think of.
It goes to show you, we were in the same field, and I had a Fish and Wildlife horror story from a very high-end client that was a very extinct species. And not a good experience. They're very serious about that.
They are.
Thank you very much, Francis. So we have a couple minutes. I think just the breadth of discussion shows you there's so many issues. It cuts across so many fields, and that's why you should buy this book. Now, I don't get anything for saying that, but this is a great book because it really gives you a range. Also, it's not one of the big books that is so hard to carry around. And it can just alert you to what some of the issues are. So I recommend it to you. But now I want to get to hear from you a little bit and see if you have any questions. We have a little time before we go upstairs and have something to eat and drink. And we're hoping we could hear what your thoughts are, your questions. And there are people with microphones. If you raise your hand, they will run towards you in a safe manner. There you go, right down here.
Do I have to stand up or, yeah? So we talked a lot about counterfeiting, but something I read about the other day was organized retail crime, in which people are actually stealing things right off the truck or right out of the factory. And a bill was just passed by the House, and the effect would be to create a department within the Department of Justice to investigate and prosecute organized retail crimes. And I was just wondering if any of your clients had been a victim of that, what impact it has on their business, or what a department such as this, how it would help your clients. It was just yesterday, so.
No. Anyone?
You never get stumped, too.
Sorry.
It's an old issue, and since Steve represents Nike, I'll mention that it's been particularly a problem over in Asia. What you see a lot of the time is factories abroad who are manufacturing goods. Their workers are actually taking the products and ripping off, whether it's the swoosh from Nike or the Coach tags, and doing that abroad. So it's not really an old issue. I've known about since the mid-'90s. As things started moving overseas, you see a lot of it from that aspect. As far as what a lot of the things you can do only happen once it hits the United States. As far as stealing them off the back of the trucks here, I hadn't heard about that. I didn't know that had happened. But overseas, it's a long-term problem, and you have to be very careful about what factories you use and what kind of security measures they have to make certain that you don't have, the missing Coach tags for 1,000 labels or something.
And one of the things that a designer company has to do when it comes to tags and labels is have a very careful inventory control of labels, because that's often the easiest way. Many companies have security devices, a little foil thread or something. That's sometimes the easiest way to identify something as counterfeit, because frankly a t-shirt can be replicated, and it can be replicated perfectly. So you need to put something on it which enables you to do the identification. So even if you have a licensee, very often companies will make the licensee buy labels from a central source, and they get to buy, if they're going to make 20,000 shirts, they get to buy 20,100 labels. There's some loss for seconds and things like that, but they don't get to buy an unlimited supply of labels, because, as Francis just said, they walk out the back door, and that legitimizes as many other garments as are bearing that label.
Other questions? Yes.
In terms of trademark protections, we've heard a lot about counterfeit goods and confusingly similar goods. What about gray market goods, especially since we have global trademarks and territorial production overseas? How would the Lomans handle that? How does the manufacturer deal with that? How does the licensor control for that?
Lomans want to opine?
That's a difficult question. As I said, when I look at the paperwork for anything that we purchase that we may not purchase directly from the designer, and again, we purchase very little that isn't directly from the designer, so it's not a big problem. But when I look at the paperwork, I look to see if there's anything on the paperwork that restricts the resale of that merchandise. And I would hope that that designers, if they intend that their merchandise not be sold in the United States, that they put that on the documentation.
So gray market goods, of course, are goods that are otherwise legitimate goods. They're just not supposed to be sold where someone's trying to sell them.
It's also a big issue when you work for a luxury brand, because when management sees product in Costco or somewhere they don't want it to be, they want to know how it got there. And the answer is, and how can we stop it? And of course, the answer is there's nothing we can do. And I have a friend who works at J. Crew, and Mickey Drexler was tormenting her about goods that were sold elsewhere than in J. Crew stores. But the issue there is the holes in your own distribution chain. And I mean, we say it to our clients over and over again. Somebody dumped those goods in Costco, and we need to find out who it is. And honestly, in small companies, you can usually find out who it is pretty quickly, and then the only solution is to cut off that vendor or that customer.
By the way, that's the reason in the counterfeiting cases that we do sue everybody in sight, because it's our job as attorneys enforcing the trademark to get to the source of the person who did the wrong deed. There are sometimes innocent people, or people who they made a quarter a shirt, and so they didn't do much, and they say, gee, what did you want? I just heard these goods were available, and I made a total of $2,000 on this, and what do you want from me? But there's somebody who traces back, and so there are worse players and better players. That we're never happy with anybody involved in the sale of counterfeit merchandise.
Yeah. If I could just mention one thing about that, it's been a perennial problem in Europe as well. People have been fighting parallel imports or gray markets forever. And I know Frances doesn't want to talk about it because she's tired. But there is kind of an exception with the Davidoff case, which is that if the product in question has been transformed for its foreign sale so that it's different from the trademark that it bears in the United States, then you may be able to get customs to help you prevent the reimportation of that product.
That's true. And you also have to be aware, though, that when people have tried to prevent gray goods from coming in the United States, they're typically unsuccessful. it's allowed unless you have an instance where you have like a chemical difference and that it's no longer such a same product, like sometimes deodorant or toothpaste. Those are the types of products that typically will be barred from being brought in the United States. But the fact of the matter is, if it's a legitimate good, it's a legitimate good.
I think we have time for one more question. Yes.
You mentioned Ralph Lauren is sort of a shining example of how of a large brand skillfully managing its licensees. I'm curious if there are any brands that sort of serve as cautionary tales within the industry of how not to manage a licensee operation.
Well, I think the one example I gave was Pierre Cardin, who made $1 billion, but was felt to have kind of destroyed his own brand. And an example that's used a lot at Harvard Business School is Gucci. Gucci was going downscale as a brand in the late 80s, early 90s. And the strategy that they pursued, which is generally felt to have rebuilt the brand, was to repurchase their license at great cost. I think there's an example of Tommy. Didn't Tommy buy back
But they did that for business reasons because
a jeans license?
Yeah, they bought back the jeans license because they realized they could do it in-house instead of making a percentage royalty. You make more if you can do it like Barbara said. If you're in a shoe company and you don't make eyewear, then you're better off having an eyewear licensee. But if it's something that you can bring people in-house to make, then you make more money making it and selling it than you do getting a percentage of it, because the part that the licensee makes as profit, you can keep for yourself. So their buybacks were not for licensee profit.
I think there are a lot of examples of large companies that were considering floating the company on the stock market and found that their market valuation was down because they were over-licensed. So by the late 90s, it became part of a company's overall strategy to get control of their brand by having the right licenses. So they tried to buy back the less productive ones.
Well, I want to thank our panelists for coming here tonight. And also to remind you that this is the second of 3 events that we have in Fashion Week here at Brooklyn Law School. We had the sit down with Chanel on Monday, and then next week we kind of extended the length of the week for this. But next week we have 2 more authors in this book coming to talk a little bit about intellectual property. So I hope you might be able to make that next week.